notifications, we have a letter from Jim Downey on the resolution. We've all had a chance to look at that. We had a notification of Jim Downey on an assessment situation. You have a copy of that. Look at that. And that brings us up to recognition of speakers for tonight. We have two speakers. We were going to have David Schwartz speak and Lincoln. Mary Jo Long will be doing the presentation for Mr. Schwartz, and Ed is here. He'll be doing his presentation. Mary Jo will go first. These speakers will address the board on the legal implications of passing a resolution supporting New York State DEC action on natural gas drilling through its supplemental generic impact study. Each speaker will have 20 minutes, after which the board will vote on the resolution. If the town board has questions, they can ask them, but the speakers are for the purpose of educating the town board on the matter of any legal ramifications. And that's the purpose of the speaker. So it's not a case of trying to educate you. If there are some questions, you can, I'll take maybe some to see how they go. You're up.
I'm just going to check my time. There is a resolution being promoted by the joint. I'm sorry, but I think people can't hear me right. In the back? No, louder.
Well, here it's hard if you can speak up, I know.
There is a resolution being promoted by the Joint Landowners Coalition, which says we, the town board of Afton, have complete confidence in the Department of Environmental Conservation, and most importantly, that the town of Afton, in this resolution, says it will not pass a moratorium or a ban on gas drilling. Before making that decision, we should know and understand all the legal impacts of saying we won't do anything to protect ourselves, and we rely entirely on the DEC. At the last town board meeting, I requested that David Slotgy, an attorney with the Community Environmental Defense Council, be allowed to speak tonight about the legal impacts of our town board passing a resolution being promoted by the Joint Landowners Coalition. I specifically recommended him because I have attended many presentations on the interplay between gas drilling and various laws. I first heard Slotgy speak more than a year ago in Portland County. Then I heard him speak in the Albany area, and the third time in Plymouth. The Plymouth presentation was fairly recent and was after the decisions came down from the courts in the Dryden and Middlefield cases. I was able to observe that his analysis of local land use authority with respect to gas drilling at the first and the second presentations on the powers that towns have turned out to be exactly right. I will explain what the Dryden and Middlefield cases are in more detail later. So when I told David Slotgy that he had only 20 minutes, well, that he only had 20 minutes to give this legal advice, he said he could not give advice with a 20-minute time limit. This was shared with the town board, and John Lawrence replied that, quote, in addressing only the legal implications or the legal burden that passing the resolution would impose on the town or town board should not take more than 20 minutes. This is not to the level of a Supreme Court case. Quotes. This is not a response of someone who wants to learn. Just as a patient doesn't tell the doctor to make an accurate diagnosis in 20 minutes, legal advice cannot be properly done in 20 minutes. An attorney who is giving legal advice must know what the client is seeking and why, and then respond with informed legal analysis to help the client achieve its goal. Slotgy felt he could not give a presentation in 20 minutes that would cover all the information needed to be shared. So I'm speaking in his stead, and I'm doing an introduction to the issues. I've been an attorney for 35 years, and I know from personal experience that 20 minutes is enough
Right here is good.
time to give an adequate legal consultation. So I've asked, and I'm limited to 20 minutes, so I've asked Slotchik to come to Afton and speak, and he has agreed to do so on Sunday, July 29th at 1 p.m., and it will be in this room. So for those who actually want to know and understand the use of local land use authority to protect health, safety, and community assets, I urge you to attend that more thorough presentation. Just like doctors, lawyers tend to specialize, even though we may know more about the legal process in general than the average person. My presentation is an introduction to the legal issues and authority that local governments have. As a lawyer and a town board member, I have made it a point to attend many training sessions for attorneys put on by the Broome County Bar Association, the New York Association of Towns, the New York State Bar Association. The gas issue raises lots of legal issues, such as real property law, which changes and separates the surface rights in property from the subsurface rights. There are issues of contract law, such as force majeure, that is, ways in which gas companies claim the right to extend leases, where people sign for $15 and make a royalty, and many of those people want out of their leases. There is compulsory integration, where people who don't want to lease are put in forced pools if the gas company's unit captures them along with 60% of leased land. That's a property rights issue that some lawyers should look into. The Joint Landowners Coalition resolution makes a lot of claims about what a wonderful job DEC is doing in the whereas clauses. It says DEC is developing standards, but I remind all of you that those standards have not been finalized. We don't know what will be in the supplemental generic environmental impact statement, nor the regulations, which DEC has not issued. We should not vote to go along with something that has not been finalized, and yet a vote is being pushed now. The regulatory process is not one that many of us have confidence in. We know that regulatory agencies such as the Environmental Protection Agency, the Food and Drug Administration, the Federal Energy Regulatory Commission, and the DEC are appointed rather than elected. Their decisions are insulated from the concerns and desires of the citizens. The inability to vote them out of office is good for the corporations who receive permits from these agencies. These agencies authorize pollution at so many parts per million, don't have adequate staff to even enforce those rules, and later the rules are relaxed even further. Many towns have sought to protect themselves through moratoria because they don't have confidence in the DEC. Two polls recently done in Shenango County show that its residents are about equally for or against this type of gas drilling. But the polls also show that more people want their local government to protect them. The Pulse poll done in June 20th to 24th asked, would you support or oppose your town enacting zoning ordinances to restrict natural gas extraction by means of hydraulic fracturing? And the answers were that 48% supported zoning to restrict natural gas extraction by means of hydraulic fracturing. 38% opposed it, and 14% were not sure. People who own land in Afton who don't have control over their subsurface rights have contacted this board.
Okay, say it.
The purchasers of the former Briggs Farm, which was sold to Norman, then sold again, have been in touch with the town board. Tom Horton sent us the following. This is a quote from him. I own a 10-acre lot in the town of Afton that was purchased as part of the subdivision of Robert Briggs' farm. There were more than 20 lots sold to about a dozen buyers. We were told we were purchasing these lands, quote, with no mineral rights. At the closing, the seller's lawyer told us there is an easement for a gas flow on one of the lots. The lawyer downplayed the actual process of gas drilling and said there would be a very small, maybe 4-foot high, well on the property. He never said the word hydraulic fracturing. In the time time since we purchased these properties, what's going on here? The realities of this process and new information have proven to be extremely destructive. We now know what not having mineral rights really means. So we, the majority of new landowners of the Briggs Farm in Afton, have signed a petition to present to you, the town board, expressing our concern and desire to ban fracking in Afton. And then he attached the petition of many people and everyone in the town board got. So towns who are opposed to gas drilling have mostly updated their zoning laws by zoning out industrial scale gas drilling. This is usually referred to as a ban. These bans have been upheld in two different cases, in the Dryden case and the Middlefield cases, and I'll discuss that a little more later. There are other towns where landowners and residents are divided, as in Shenango County and here in Afton, or where the town board is undecided. Some of those towns have passed moratorium instead of a ban. A moratorium is not zoning. It is a temporary pause in a proposed activity that the town wants to consider, to study, or study more. A moratorium passed now would give a town board more time to determine what is best for their town after the DEC issues its regulations and its SGEIS, and that's the initials for a very long term that stands for Supplemental Generic Environmental Impact Statement. Towns who are not certain of whether fracking is appropriate for their communities, either because residents are divided or undecided, should preserve their options by adopting a moratorium. This should be done before the DEC issues its SGEIS, because DEC will issue permits as soon as the SGEIS is promulgated. There are zoning powers which local governments have to control the location of energy and other non-resident enterprises. There are also police powers, which is set forth in the Municipal Home Rule Law. Police powers is the power towns have to protect the health, safety, and well-being of persons and properties in the town. The police power is a much wider authority than zoning, and some towns are considering using their police power and not having zoning. Other towns are working to do a comprehensive plan and then consider whether this is the kind of economic activity that the community wants. For those who want local governments to protect us, Slotchie's longer presentation goes into the details and the various options. One of the provisions of the most recent draft of the SGEIS is that before a permit is issued, the corporation requesting the permit must say if this form of industrial scale drilling is, quote, inconsistent with local land use laws. So if a town has a moratorium or a local land use law, then the company applying for the permit has to notify the DEC and be aware of it. If this Joint Land Owners Coalition resolution is passed, we will reduce our ability to act in the future. There will be no local land use laws, which DEC must consider in Afton. We are saying that whatever the rules are, we want fracking here first if we pass this resolution. Two courts have upheld towns' right to pass bans. The Anschutz versus Town of Dryden case was decided February 21st of this year, 2012. And the Cooperstown Holstein Corporation versus Town of Middlefield was decided February 24th of this year. Those towns had zoning laws that zoned out industrial scale, high impact gas drilling activities. The courts held that the Environmental Conservation Law at section 23-0303 subsection 2, which has preemption language, gives the DEC the right to, quote, regulate, unquote, the gas drilling industry, but does not preempt local zoning laws. The courts state zoning is not regulating the gas industry, it is determining location, and that power can include the right to ban it from the entire town or to certain sections that they want. While the Joint Landowners Coalition would like us to declare we won't act, others argue we should wait until we know the outcome of the appeal of these cases. And a notice of appeal has been filed in these cases. I should tell you, though, that lawyers tend to not consider that an appeal. It's an option to do an appeal. A notice of appeal has to be filed in a certain amount of time, but you have 9 months, usually it's 9 months, to perfect your appeal. And to date, although notices of appeal have been filed, there has been nothing filed to show that these appeals are actually going to be perfected. While the Joint Landowners Coalition would like us to, oh, well, that was right. So this is not a fiscally prudent thing to do, to pass this resolution. Waiting to pass a protective law until after permits issue actually exposes the municipalities, taxpayers, to a greater liability if it decides eventually it needs some protective laws. In other words, we have to act before the DEC starts issuing permits. Once the permits are issued, the holder of the permit has a claim for a taking. Before permits are issued, there is little likelihood that a taking claim would succeed. The threat to sue and make a taking claim is a boogeyman that is used to intimidate town boards, but threats to sue are a dime a dozen and only cost a dollar. Tom West, who actually is the attorney who represents Anschutz in the kind of lawsuit, threatened to sue Dryden for millions of dollars, but when he actually filed the lawsuit, he did not sue for any money at all. He filed for a declaration that their zoning rules violated the Environmental Conservation Law, and the judge ruled against him. He lost. And the reason he didn't sue is, he's the go-to guy. He's the go-to attorney for the gas industry. He didn't sue for any money, despite his threats. And that was because he knew that he would lose a takings claim he tried to make at that point. Waiting until permits are issued means that the holder of the permit has a better claim that this is a taking. That's why the gas companies don't want moratoria or bans prior to the DEC beginning to issue permits. We would be giving up that powerful tool to protect our town. So, as I said, if they don't file within 9 months to perfect the appeal, then the appeal is basically waived. No one has perfected their appeal yet, if they ever do. And it happens often that notices of appeals are filed and the attorneys don't perfect their appeal. They just keep the option open. The one, I think my time is almost up, and I just have 2 other comments. It was mentioned here that that our town attorney, which is Jim Downey, had been consulted on whether we should have this joint landowners coalition resolution. And he says several things, but one is that it is probably legal for a local municipality to adopt a temporary moratorium on drilling activity within the town, to allow the town sufficient time to obtain public comment, investigate pros and cons, and draft zoning laws. He also says, further on, that adopting the resolution is contrary to my recommendation. Contrary to my recommendation. His recommendation is the board do nothing. If it is of the collective opinion not to exercise its limited authority under Environmental Conservation Law 23-0303, subsection 2, as delineated in the Dryden and Middlefield cases. He says, either exercise your rights and authority, as we have been allowed to, and as it's been validated in the Dryden and Middlefield cases, or do nothing. And do nothing does not mean, do nothing means, do not adopt canned resolutions submitted by either side of the issue, especially without affording your constituents the prior opportunity to offer comments at a public hearing. He also said he cannot with any degree of certainty state that adopting the resolution would result in legal troubles for the town, but I can state with greater certainty that declining to adopt a resolution will be less likely to result in legal troubles, a lawsuit, financial obligation on the town's part. And if, and I'm going to stop there, except that as an attorney, I reserve my right for rebuttal. If Mr. Zengel goes over 20 minutes, I want as much time as he has if he goes over 20 minutes.